Right. So then let's get rolling for this January 20th, 2022 special meeting of the Conservation Commission. So it sounds like we've got everybody speaking, and so we know we're all here. Good. So good evening. This January 20th, 2022 open meeting of the Newbury Conservation Commission is being conducted remotely, consistent with the act relative to extending certain COVID-19 measures adopted during the state of emergency, which extends the governor's March 12th, 2020 order suspending certain provisions of the open meeting law until April 1st, 2022. This order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location and allows public bodies to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. Please note that this meeting is being recorded and that attendees are participating by video and/or telephone conference, and the recording will be available on the Newbury Access YouTube channel. Before we turn to the topic of the agenda, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I, as chair, will introduce each item on the agenda. For all attendees except commission members and staff, please remember to mute your computer or your phone when you're not speaking. Please remember to speak clearly and in a way that helps generate accurate minutes. Please be aware that video participants can see you and that you should take care not to screen share your computer. Anything that you broadcast may be captured by the recording. If commission members wish to engage with each other, please do so through me, taking care to identify yourself when you wish to speak. Regarding public comment, there will not be an opportunity for public comment or questions during this meeting. Any questions from the public regarding matters discussed in this meeting should be directed to the conservation agent. Please note that the chat feature has been disabled for this meeting. Please also note that everyone is expected to conduct themselves in the same manner they would at an in-person meeting. Any disruptions will be addressed once by the chair and must be acknowledged. Any further disruptions will result in complete removal from the meeting with no readmittance. Vulgar or obscene actions or comments will result in immediate removal from the meeting with no readmittance. Finally, each vote taken in this meeting will be conducted by a roll call vote. And yeah, good. So that is the script. Now, turning to our agenda.
Mr. Chair.
Yeah.
I don't know if you've been doing this or not, but you should take a roll call attendance at the beginning of the meeting. I know you noted that everybody spoke, but you should take a roll call attendance.
So Lisa, from a technical standpoint, my presumption was that we were just making sure the internet connections were good. Is there more of a reasoning there?
Yes, because what if somebody's listening on the phone as opposed to watching on Zoom? So you need to take a roll call attendance.
Fair enough. All right, let's do that then.
Is that a roll call attendance just for commission members and staff, or is that for anyone in attendance?
Just commission members.
Okay. Sorry, go ahead.
Brian Colleran, chair, and then Ben Gahagan.
Yes.
Brad Duffin.
Present.
Dan Streeter.
Yes.
Frank Wettenkamp. No.
Frank's here, but muted.
There you go.
Yes, I'm here.
There we go. Mary Rimmer. Mary said she couldn't come. And Peter Pecos.
Frank.
And town staff, Samantha Holt, conservation agent.
Yes.
Okay, thank you. All right, so Lisa, that was a great start to the training session.
There you go.
So why don't you take it away then?
Okay, thank you, everybody. For the record, I'm Lisa Mead, and I'm town council with the firm of Mead, Tellerman, Costa at 30 Green Street in Newburyport. I'm going to share my screen. While I'm doing that, I have an echo.
Oh, Lisa, hold that thought just for a second. Sam and I talked. She has a quick announcement she wants to make about what she's up to.
Okay.
Before I forget.
So just a quick little sort of training update. There is a MACC, the Massachusetts Association for Conservation Commissions training coming up on the 25th that I am attending. It's the Fundamentals 102 course that I've been registered for. MAC also has a whole bunch of stuff coming up. The MAC conference is between March 1st and March 12th. The schedule for that has not been released yet. Once I do get the schedule for that, I will send it out to everybody just in case there are classes that you'd like to take. The fundamentals courses schedule has been posted for the entire month of March. As well as February, in case anybody is interested in those. If you are interested in taking any of the MAC fundamentals courses, please let me know. Send me an email or give me a call and tell me that you want to take it, what class you want to take, and what the date is. And I will sign you up, because the town, you're covered under the dues for MAC for the town as a voting member of the commission. And we get special rates as MAC members. And it's easiest if I sign you up so that the town doesn't have to reimburse you. So it just gets paid for through our budget. So if you are interested in taking any of those classes, please let me know. And not that the certification is coming anytime soon, because it's going to take a while for me to get through the process for it. I am in the process of getting the certified floodplain manager course done. I've done the independent study prerequisite courses for that. And I am also in the process of doing the wetland professional in training certification through the Society for Wetland Scientists. Just in case anyone cares.
There you go. That's great. Thanks, Sam. So this evening, and just so you know, I can only see some of you because I've all got my screen up with my, can you all see the first slide?
Yes.
Okay.
Yes.
So Sam asked me to do a couple of things, and the chair asked me to do a couple things. So first I'm going to do a training on the open meeting law. So if you do have a question, you can speak up. Or we can I'll pause during various sections, or just interrupt me because I can only see 4 or 5 of you. And then after that, I'm going to talk a little bit. You had submitted a couple of questions in advance, so I can answer some of those. And then I'm going to, somebody is like scratching, so I don't know what that is, but if maybe you could all. Then I'm going to go through, I think, some of the questions related to your proposed amendments to the bylaw a little bit, an overview. So the open meeting law. The open meeting law is found generally at 30A section 18 to 25 and 940 CMR 29 of the regulations. It's what you call on a federal level, some refer to this as the sunshine law. But it's an idea is to let people know what's happening in their government, so that everybody sees what their public officials are doing. The Office of the Attorney General administers the open meeting law. The person responsible for it we commonly refer to as the dog officer, the chair of the Division of Open Government. That's kind of a mass lawyer's little inside joke. And they're also very helpful with preliminary determinations and working through issues that might arise prior to potential violations. For you who may be more new to municipal government, prior to 2010, the open meeting law was enforced by the various county district attorneys. And therefore, each district attorney's office had its own interpretation of the then existing open meeting law. And so what Kevin Burke, who was the district attorney in Massachusetts a while ago, would think was a violation under the open meeting law might have been different than Scott Harshbarger, who is the Middlesex district attorney, and how he interpreted the open meeting law. So that was rectified by the legislature when they gave it to the attorney general to enforce. So there's a couple of key definitions under the open meeting law. One is the public body. So who does it apply to? It applies to all public body. What is a public body? Public body is a multi-member board, committee, or commission that's been established to serve a public purpose in the town, including subcommittees created to advise or report to the full body. So sometimes out of convenience, let's say it's a planning board and it's a 9-member planning board, and they might want somebody to go meet with an applicant to talk about, some details in a plan to change. And somebody might say, well, the chair might say, well, Sam and Mary, you go meet with the applicant. And that'll be okay because we won't have to post that meeting. Well, that actually is a subcommittee, and that meeting would be subject to the open meeting law. So any subcommittee of a public body is also subject to the open meeting law. Then what is it that is protected? And that is deliberations. Deliberations include any written or oral communication, including communication via email and or other electronic medium between or among members of a public body on any public business within its jurisdiction. This does not include the distribution of meeting materials, scheduling information, or reports or documents to be discussed at a meeting. So if the chair sends out to all meeting members, we're going to have a meeting on January 20th. Here's the agenda and here are all the materials. That's fine. You can do that. What can't happen then is one of the members to reply to the chair, reply all and say, well, this is the most ridiculous thing I've ever seen on this agenda. We shouldn't have item number 3 on the agenda. That, I hate that item on that agenda. That then starts to be a deliberation. So you can distribute materials, information, reports, documents. You can actually talk about dates of meetings, but you cannot deliberate over anything else. What is between or among? Well, that's a really interesting question because that recently became the subject of a complaint actually in the town of Newbury. And the Attorney General's office has taken a very narrow view of what between and among means. And I'm going to talk about that in a little minute when we get to the exceptions. What is an intentional violation? So this is important because intentional violations can lead to fines. So intentional violations means essentially acting with a specific intent to violate the law, acting deliberately in deliberate ignorance of the law, or in contravention to previously informed by receipt of a decision of the court of competent jurisdiction or advice of the Attorney General. So if you made a good faith attempt at compliance, but were reasonably mistaken, that is not an intentional violation. So I will tell you that the Attorney General's office is very reasonable in this regard. It really has to be egregious to be intentional. I will also tell you, however, you are deemed to know the open meeting law because when you are sworn into office, the town clerk is supposed to give you a copy of the open meeting law, and therefore you're deemed to know. So ignorance of the law is not an excuse. So what's a meeting? A meeting includes all deliberations of a public body, but it does not include the following, provided no deliberations occur. So this applies to you, on-site inspections of a project or a program. So prior to 2010, it used to be that if you were going to go do a site visit, you would have to post that site visit, and that was subject to the posting requirements. Now you don't have to publish the site visit 48 hours in advance. You can just do it. You don't have to even schedule it at a meeting. You can do it in between meetings, but you may not deliberate at that site visit. So the purpose of the site visit is for acquisition of facts, to view the area and acquire facts. You deliberate over what you found when you get back to your meeting. Attendance by a quorum of a public body at a public-private gathering, including a conference or training, program or media or social or other event. So let's say that the training that Sam just talked about that's available to all of you through MAC, let's say you all went to that training together, that would be okay. That's an exception. You can't meet at the back room of that training and start to deliberate over a particular matter that's in front of you, but you can all go to the training together. Another exception is this, and this is the one I wanted to talk to you about. Attendance by a quorum of a public body and a meeting of another public body that has complied with the notice requirements of the open meeting law, so long as the visiting members communicate only by open participation in the meeting on those matters under discussion. So if you attend a finance committee meeting all of you. Before 2 weeks ago, I would have said to you, you don't have to post your meeting because the Finance Committee has posted the meeting. You go and sit in front of the Finance Committee and you answer their questions and you walk away. However, the Attorney General's office has very narrowly now defined this exception and has quite frankly told us they don't even know why the exception exists. And so therefore, our advice is that if you attend, a quorum of you attend another meeting of a public body, even though the other public body has posted their meeting, that you too should post your meeting, even if you don't think you're going to deliberate, just in case. And if in fact you speak at that meeting, minutes must be taken and kept in accordance with the public records law and the open meeting law. They have very narrowly defined what deliberation means here. They have defined that if you communicate on something that you haven't yet addressed at a public meeting or decided, that becomes between or among, even if you don't sit together and even if you don't answer the same questions.
Lisa, the question for you on that particular
Yes.
item C.
Yes.
Would that include town meeting if we all went to town meeting?
No, as you can see, the exception E, there is a special exception E for town meeting.
Okay,
Now, I will tell you that usually not the Conservation Commission, but sometimes the Planning Board, the Board of Selectmen, or the Finance Committee may actually have to meet before town meeting or right after town meeting. So I always post those meetings anyway, because they may have to meet and take votes at before town meeting. But if you're merely all attending town meeting to vote on whatever articles are to be voted on or to present an article by the Conservation Commission at town meeting, you need not post that meeting, at least today. A meeting of a quasi judicial board or commission, this actually doesn't apply to municipalities. So what about the meeting notice? Meeting notice has to be posted at least 48 hours prior to the meeting, excluding Saturdays, Sundays, and legal holidays. The notice must include the purpose of the meeting, the agenda, and any other matters the chair reasonably believes will be discussed. And this is the source of some discussion now and again. So 3 days before the meeting, the chair makes up the agenda, or a week before the meeting, the chair makes up the agenda. The chair posts it. Now we're 24 hours in the meeting, and all of a sudden somebody comes up to the chair and says, oh my gosh, I forgot to put this request for a certificate of compliance on here. We didn't know about it. We were just asked about it. Should we put this request for a certificate of compliance on the meeting? You may do that. You may add it if you didn't reasonably anticipate it at the time you put the agenda together. Notice must be posted in or on a public building that houses the clerk's office and must be visible to the public at all times, 24 hours, 7 days a week. Now, there are alternative posting methods, and the town of Newbury does have an alternative posting method, which is the website. That has to be approved by the Attorney General's office, and it's actually on file with the Attorney General's office. Anybody can go to the website, open the PDF or Excel spreadsheets that has the postings of every single municipality in Massachusetts. So the Attorney General has emphasized in a number of their determinations that the meeting notices have to include sufficient information regarding the topics to be discussed at the meeting, such that it reasonably informs the public of what will be discussed, including the topics to be discussed in executive session. So it's rare that the Conservation Commission would go into executive session unless a matter of theirs is appealed and it's under litigation. But those times you could. So a meeting notice has to state the name of the applicant and noting it was a request for an extension. Oh, so this is an example, excuse me. Here's an example of something that was a challenge to the open meeting law in another community, and it happens to be a Conservation Commission issue. So the Attorney General's office determined that a meeting notice stating the name of the applicant and noting it was a request for an extension of order conditions was found to be insufficient. And the reason that was that they noted that all other items on the agenda were listed as public hearings if in fact they required to have public hearings. while the notice of the extension was not identified as a public hearing, although in that town it had to be a public hearing. And so the AG's office determined that since it was supposed to be a public hearing and it wasn't noted as being a public hearing, that the announcement or the agenda was insufficient. And so you do have to be careful to include, I would typically include the name and address of the matter at which the matter under consideration, order of conditions, ANRAD, whatever it is, and whether or not it's a public hearing. Another determination of the AG's office, just to go a little bit further into this, the AG's office noted that notice of an executive session must state all subjects that must be revealed without compromising the purpose for which the executive session was called. So, for example, litigation not yet commenced but contemplated by a Board of Selectmen need not include specifics. So if the Board of Selectmen is considering filing a lawsuit against somebody or appealing something, but hasn't yet done it, they only need to state the exemption that allows them to consider litigation. However, if the litigation is already filed, so let's say you already have an appeal of record, then the notice in the executive session must include the name of the case in the notice of executive session. The AG's office found no violation, as I noted, also related to a purchase and sale agreement. So typically the Board of Selectmen, or even you, because you have the authority to buy land, you have the right to go into executive session to discuss the value of property, okay, the purchase and sale of property. If you don't know the address or you haven't yet made an offer, you might not want to put the address in the notice, and that's okay, because you don't want to give away your negotiating position. If the P&S has already been signed and has been made public, but if there are changes or contingencies that haven't yet been resolved, you can go back into the executive session to discuss those contingencies or to discuss further negotiations related to any compromises that have to exist related to the purchase of the property. So that's an important exception as well. And it just needs to, you just need to be careful on how you draft it. So the, as I said earlier, the dog officer has approved the following alternative posting methods. In Newbury, you posted on the municipal website. That was effective in 2018. Just a few others. If you ended up not doing that, you can post it on the cable television and post it in alternative building locations that are open at all times. So when this change first occurred, there are some really small communities in the hill towns in Western Mass that still didn't have internet access or even cable access. And so they were looking for alternative methods that those communities could still comply with the posting. So if they had cable, they might have it on the community access station in the police department 24 hours a day, or in the fire department 24 hours a day. You could post it every day in a newspaper, which is crazy, right? You could post it on computer monitors or bulletin boards at the entrance to municipal buildings, so it could be seen 24 hours a day. I had one town when this first came out, they built a little box outside of town hall and had a notebook in it, and people could go look in the notebook every single day if they wanted to. Or you could provide an audio recording of all meeting notices available on public telephone at all times if you wanted to. Coincidentally and conveniently, Newbury has it on their website, which is most all communities do now, but not all. If you do adopt an alternative method, as I said, the town clerk has to notify the AG in writing and include the website if that's the alternative method. And you can change it at any time. It's the Board of Selectmen that changes it. And the clerk just has to notify the AG via written notice of the change. In an emergency situation, you can meet with less than 48 hours notice, but it has to be an emergency. And if any of my clients ever come to me and say, I need to post a meeting right away because I forgot, That's not an emergency. An emergency is any sudden, generally unexpected occurrence or set of circumstances demanding immediate action. So you guys actually may fall under this at some point in time. Certainly the Board of Selectmen do regularly, sadly in our current situation under COVID or under like big storm events. A few years ago when Newbury was losing houses, now it's Newburyport's turn to lose houses. They might meet in an emergency situation to decide what they're going to do, if they have extra money to spend or things like that. You might meet if there's like some kind of emergency spill or flood that you might need to have the agent take certain action. But it would have to be a sudden or generally unexpected occurrence. Otherwise, it's 48 hours. So as you know, because of COVID, right now, we're allowed to meet remotely. We can meet in a hybrid situation. We can meet remotely like this. But without this exception, generally, the body needs to meet in person. There is a section of the law that allows for remote participation as opposed to a remote meeting. But the quorum of the body has to be present at the meeting location. And so a quorum of the body may not be meeting remotely, unlike in our current emergency situations. If the Board of Selectmen allow a public body, and they can allow one public body or they can allow all public bodies, but they have to vote to allow it. If they vote to adopt the remote participation, then there is a list of rules that have to be followed by the chair and the members in order to do that. So if you're going to do remote participation, which is different than a remote meeting, I want to be very clear, we're not talking about the COVID situation. We're talking about pre-COVID and hopefully post-COVID. The chair of a public body has to announce at the start of a meeting whether the meeting is being video or audio recording, and it must include those being recorded by private individuals. The meeting, if it's being held remotely, that has to be announced. If the meeting is, the chair has to announce how to access the meeting. And if the meeting is being held remotely, there also must be a roll call vote at the start of the meeting for every vote. I'm sorry, these are the rules right now for the COVID. I apologize, I put this in there. So those are the rules for COVID, and that's what the chair did at the beginning of this meeting. Generally speaking, to address a meeting of a public body, permission of the chair is required. And it's kind of like being the moderator. I say the moderator is the king at town meeting. His rules are the rules, unless challenged appropriately. Here, the chair is the chair of the meeting, and everything has to go through the chair. The chair is not required to allow the public to participate in a public meeting, as opposed to a public hearing, which is held under another statutory scheme. And so you all have public hearings. In your public hearings, you always have to allow the people in favor or opposed to speak. But if it's not a public hearing, the public does not have to be allowed to participate. And a thoughtful approach to public participation should be undertaken where their participation is not part of a public hearing process. So I will tell you that this also is a current stickler for some people. You do need to be really clear about how you're going to allow public to participate. My recommendation is that you state, if you decide you're going to have public participation, that you're very clear at the beginning of the meeting that there will be public participation, what the rules are, how long each person can speak, and for how long the public participation can go, and about what the public participation is allowed to be discussed. So some people say you can only have public participation about things that are on our agenda, okay? You can only have public participation about things that you might want to have on the agenda. Everybody can speak for 2 minutes. We're only going to have public participation for the first 15 minutes, okay? And you have to evenly apply that, or nobody can speak. And that's fine too. But if you allow people to speak, you cannot shut them off for the content of their speech. You may only provide rules about time, place, and manner, not content. So here's my outside of COVID emergency order. So the Board of Selectmen has to decide if they're going to allow remote participation. The chair has to determine that physical attendance will be unreasonably difficult for the person not participating in person. And acceptable methods of remote participation have to include any technology that enables the remote participant and all persons present at the meeting location to be clearly audible to one another. Now, I have to tell you, in the last 2.5 years, it's like we've come 50 light years, right? So I remember before COVID, if there was going to be remote participation, I literally participated in meetings where somebody was remote and they threw their iPhone, the chair put the iPhone in the middle of the room, and the remote participant, spoke over the iPhone and everybody could kind of hear what was going on. Well, we've come a long way for remote participation, and I suspect that after we have to go back into in-person meetings, that it will be expected that better technology is used. And this may even change to be video as well as audio. So the minimum requirements for remote participation is all quorums must be physically present at a meeting location. The members participating remotely and all those present must be clearly audible to each other. All votes taken must be by a roll call vote. The chair has to announce at the start of the meeting who the remote participation is and why, like they're gone, they're sick. Remote participants may vote and are not deemed absent. They may participate in executive session, but they have to state at the start that no one else is with them or present that would violate executive session. Anytime a technical difficulty becomes during the use of remote participation ineffective, then the chair has to decide how to address the issue. I do want to say one other thing about remote participation. The person who is participating remotely cannot make the quorum. The quorum has to be present at the public meeting in person. So let's talk a little bit about email. My advice to members is receive your information via email and don't do anything else on email, because it's just too easy, the way we communicate these days, to slip into conversations. And that becomes potential violation of the open meeting law. So deliberations or discussions via email of topics within the board's jurisdiction. And if you do that, it's a violation of the open meeting law. Email communications must therefore be limited to distribution of meeting materials and similar information. It is suggested at the end of all of your emails, you have a statement that says, this email is for the distribution of materials only, not for discussion purposes. I also like to add, do not reply all. Here's a really interesting case. The AG's office found that a communication via email constitutes deliberation in violation of open meeting law where there was a study committee. So this case took place in a small town in central Massachusetts, where there was a small study committee who volunteered to review, I think it was the water quality issues that they were having in town. They were all professionals, all very busy, just like all of you. And in this case, the study committee created a voting grid, and they thought they would be going to be efficient, right? The next time they met, they were going to be focused and efficient. So the study committee created a voting grid addressing a number of the potential issues, which the chair circulated via email to the members of the committee. So that was okay. Then, though, the AG found that every email exchange containing completed voting grids constituted an open meeting law violation as an improper distribution. So when those grids were returned to the chair, that constituted an improper deliberation because there was ideas and information in those grids. The circulation of the blank voting grid was not found to be a violation. So one way to avoid this, had they had a staff person, which in this town they didn't because they were so small, had the staff person distributed the voting grids and then had the members individually return those completed grids to the staff person. That would not have been a deliberation. If the staff person then consolidated those grids and distributed those to the members and posted them publicly at the same time, that would be okay. But if they distributed them to the members without posting them, it would be a violation of the open meeting law. The staff person could also distribute them at the open meeting itself, and that would be okay too. So executive session, again, the only reason you all should really go into executive session is likely for litigation or maybe the purchase of property because you have the authority to do that. So I will tell you just generally, the reasons for executive session are to discuss the reputation, character, or physical condition and mental health of an employee or staff member or individual. However, in this instance, that person has to be given notice of that meeting. You would not have such a meeting. The conduct of strategy sessions in preparation for negotiations with non-union personnel or collective bargaining or contract negotiations, that's allowed in executive session. Strategy with respect to collective bargaining and litigation, if the open meeting will have a detrimental impact on the position of the board. To discuss deployment of security personnel or devices, to investigate charges of criminal misconduct or filing a criminal complaint, to consider the purchase, exchange, lease, or value of real property. This you may have a reason to go in for. To comply with or act under the authority of any other general or special law or federal grant and aid requirement. A lot of people say, well, what is that? What is that? So one board that is constantly in executive session is the Board of Assessors. And that is because the Board of Assessors, under their act, when somebody seeks an abatement, is given personal financial information, and they go into executive session pursuant to their statutory authority. And that's an example of that. To consider or interview applicants for employment in a preliminary screening committee. And the purpose of this is to encourage people to apply for municipal jobs, right? So if you're applying for a job and you don't want your current employer to know that you're applying for a job and there's a screening committee, then the information can go into that screening committee and be confidential. Indeed, the people who are not moved on to the final committee who makes the decision, that information will never become public. It's never a public record, and it is never subject to disclosure under the open meeting law. So you're really protected if you're applying for a municipal position and there's a screening committee. If there's not a screening committee, it's all open. It's all on the table. To meet or confer with a mediator. This was a new one in the last couple of years to encourage mediation and resolution of litigation. And then to discuss trade secrets or confidential and competitively sensitive information related to energy suppliers under the Department of Utilities. All right, here's an important section, minutes. Minutes have to include a summary of discussion of each subject, list of exhibits, and list of exhibits used at the meeting and decisions made, including all record of votes. Okay, so minutes are not transcripts. I have some communities who literally do a transcript of the recording of the meeting and that becomes the minutes. Those are not minutes. Minutes are a summary of discussions and decisions made. Who was there? Who spoke about it? And you have to include a list of exhibits. This is something a lot of people forget. You have to include a list of exhibits used at the meeting. So if Sam hands out 5 exhibits for you, an order of conditions, an explanation of new changes in the Wetlands Protection Act, potential modifications to your bylaw, those all have to be listed on the minutes. The exhibits actually become a part of the official record of the meeting. Minutes of executive session must be disclosed when the purpose for which the executive session was held has been served. Sometimes it can be years, sometimes it can be one meeting. It just depends on the matter. I had a case in another town I represent where litigation actually went on for 7 years and executive session minutes were not released until after it was over for those whole 7-year period for that matter. Minutes have to be released at regular intervals. A public body shall review the minutes of executive sessions to determine if continued non-disclosure is warranted.
Lisa, can I ask a quick question?
Mhm.
Where for the exhibits thing, does that include like when an applicant brings in like a display board to show something that they already have? That like the commission already has?
No, unless it's different. So sometimes, and it's changed a lot with COVID because of the way we do presentations, but I recall, 5 years ago, it would not be unexpected that at a meeting after the original filing with the commission, at a meeting, somebody would pop up and say, oh, by the way, I'm adding this building, or, oh, by the way, I've decided to make this driveway go in this direction. That then has to become a part of the meeting minutes, and you should require them to give you an appropriately sized copy of that document or an electronic file of it. It should be part of your regulations that anything that is produced at a meeting that's different from what has already been submitted has to be provided to the commission.
Okay, and is just a like sort of bulleted list of what was included in that, like any exhibits that are relevant to that particular hearing included
So
on the minutes?
if somebody makes a submission, say I have a cover letter on a submission for an order of conditions and it includes 10 exhibits, right, in that order, I'm going to say, submission dated, 1/20/22 by Attorney Mead for the order of conditions for 13 Smith Street. Right, that's the entire package that I submitted. Now that includes 100 pages, but that's the entire package I submitted.
Okay,
Okay.
all right, thank you.
Lisa, I want to ask a question on that point as well, actually.
Okay.
So that should be in our regulations you just said. Is that the regulations of the town or of the body?
No, of the body.
Okay.
Everybody has their own submission should have their own submission requirements in their regulations.
Okay. So, right. So then, to our point later on, currently we couldn't do that.
No, but you could adopt regulations that require it.
Well, right. For a discussion later. I'll let you get back to your.
Right. But you can't, but let me
Thank you.
also say, because it's a requirement of the open meeting law, you can just make them do it right now, but it's way easier to have it in the regulations.
Okay.
So minutes of all open sessions have to be approved in a timely manner. There's been a decision of the AG's office that found a board meeting on a regular basis, a delay of more than 2 or 3 months in preparing and approving minutes constitutes a violation. Another case found that not only that minutes were not approved in a timely manner, but that minutes did not contain sufficient detail or accuracy. In that particular matter, the person who was taking the minutes kind of picked and chose who they were going to say who commented on things, and only put the people that commented in the way they wanted them to comment in the minutes. So if you're gonna parse out that certain people spoke in favor or certain people spoke opposed, you need to say, you need to be accurate and fair-handed about that. All complaints of the open meeting law must be filed with the public body and the town clerk within 30 days of the alleged violation. Now, just as one of the changes in 2010, it used to be that there was no time limit on that, and that became really kind of crazy. So within 30 days of the alleged violation, and then within 14 business days of receipt of the complaint, the public body has to take necessary remedial action and send a copy of the complaint and description of remedial action to the dog officer. Now, it may be that there's no remedial action that's necessary. Maybe the complainant is wrong. However, in that same 14-day period, the response you give to the dog officer and to the complainant has to be approved by the body. So previous to about 4 years ago, it used to be that town council in most every community just worked with the chair of whatever body and drafted a response. And there was a determination made that said, no, it has to be a response of the public body. And so this actually is another reason to go into executive session, because complaints on the open meeting law can turn into litigation. And so now we prepare a response. We meet with the public body about the response, and then we send the response. I will say that if in fact there has been a violation, the open meeting law is one of the easiest statutes to comply with and fix. So let's say you didn't list something properly on the agenda. Recently I had a town who did not announce all the members at the beginning of the meeting, and they got a complaint about that. And so at the next meeting, they announced the members at the beginning. They had an item on their agenda to say to remedy a potential violation of the open meeting law. They redid that all over again. They revoted what they voted for, and then they remedied the matter. And then we sent the remedy back to the Division of Open Government. So while it may be a little bit embarrassing or pain in the rear end, it's easy to fix, and you just got to get over it and move on. Everybody makes mistakes. Nobody does this stuff on purpose. And it's easy enough to fix. If the public body does not take the necessary remedial action within 30 days of receipt of the complainant may file a copy of the complaint with the dog officer. However, if you do file and object, like let's say, I don't believe that I made a mistake, right? The body didn't make a mistake. They posted it properly or whatever. The dog officer will issue a decision in that manner. And then they'll decide whether or not it needs further investigation. So how do they resolve open meeting law violations? They require immediate or future compliance. They can require attendance at training sessions like this. They can require the minutes or records of other materials be made public in case they weren't. They could actually nullify the action taken by the public body. That actually is one of the worst possible outcomes. That's why I always say, look, if there's really been a violation, fix it. It's easy enough to fix. You fix it in 48 hours, right? Fix it. Or they can impose fines. But that's, I have to tell you, to be have a fine imposed would be a pretty egregious action. It is not something that happens frequently. They have the latitude to take other appropriate action as well. As I said in the beginning, all municipal employees are deemed to have knowledge of the open meeting law because you're supposed to get a copy of it when you get sworn in. Therefore, any violation could be considered willful because of your knowledge, but typically that's not the case so long as you've taken your actions in good faith, even though they may be incorrect. The AG's office may also issue advisory opinions that you can request on your own initiative, or I can request on our own initiative. I had a community that had a person who was constantly making open meeting law complaints, rightly or wrongly. And I had a town manager who wanted to take an action and appoint his own advisory committee. And we knew we were going to get a complaint from the citizen because everything, the citizen complained about everything. So we sought an advisory opinion from the Attorney General's office. We got it in writing that the town manager could appoint his own advisory committee, not subject to the open meeting law. And as soon as they had their first meeting and the person found out about it, they filed a complaint with the Division of Open Government, and we provided the advisory opinion, and it was dismissed. So that the public body, even if the Division of Open Government was wrong in issuing that, the public body who relies on that, or the public entity who relies on that, will not be deemed to have made a intentional violation. Oops, it's sideways. There's a picture I did earlier. That's a Plum Island lot 6 last summer. lot 6. I was fly fishing at 5 o'clock in the morning. That was about 4:30, 5 o'clock. And I don't know how it got sideways because it wasn't sideways when I put it together. Okay, so any other questions about the open meeting law? Do your best. People don't make mistakes on purpose. Typically, if there's a mistake made, call us, let us see the complaint. We'll help walk through it. Maybe you didn't make a mistake at all. And if you did, it can be easily rectified. So some of the questions that you all asked, or that at least Sam sent to me about the bylaw and public hearings. So the first question was, is the commission required to open public hearings under both Chapter 131 and regulations, as well as the local bylaw? And under 310 CMR 10.05, I suggest you can go there. But there's 10.055, public hearings by the Conservation Commission. So it gives you a list of those things that you are required to have public hearings about, which is almost everything. But in addition, your local bylaw section is also a public hearing. So when you go to open the public hearings, you say, we're opening the public hearing for a request of an order of conditions for the property at 5 Main Street. That would encompass both the state and local bylaw. Was that did I answer that question?
So the question that I got, so it was a question that Mary had, and it was kind of like, when we open a public hearing, we say, you know, this is a public hearing for 5 Main Street. This is the applicant. This is what the public hearing is for. This is a description of the project. And then we just go immediately into presentation and discussion.
Yep.
Her question was, do we open it, say it's 5 Main Street, this is the applicant, DEP file number, we're opening this public hearing under Mass General Law, Chapter 141, Section 40, or 30, or whatever it is. And we're also opening it under the Town of Newbury Wetlands Bylaw, Chapter 95.
You don't
Do we have to announce that before the public hearing can continue?
No, you can do it. You can just say we're opening a public hearing for the issuance of an order of conditions, right? You can add that. You can say pursuant to Chapter 131 and the local bylaw. You know, that there's nothing wrong with that, but an order of conditions issued by your board requires a public hearing under both. So either way is fine. Okay. So there's then the question, can I provide an explanation of the reasons the town is not changing the bylaw as it pertains to Plum Island from a legal standpoint? What kind of process would we need to go to in order to change the bylaw for Plum Island? So let me just say to you that you certainly can change the bylaw from a legal standpoint for Plum Island, for sure. The genesis of the local bylaws for Plum Island and the revisions to them were out of the water and sewer project and the administrative consent order. So first of all, if you were going to change them, you would want to make sure that any changes were consistent with the administrative consent order. And I will tell you that the current changes were consistent, right? Because the DEP accepted the local bylaw at the time as a condition of the administrative consent order. You can make them more strict than what you currently have, but if you were to make them more generous than what you currently have, I would be concerned about if they ran afoul of the original purpose under the administrative consent order. Okay. Does that answer that question?
Lisa, just for those who may not know, like myself, could you explain an administrative consent order in a little more detail?
Sure. So I guess this is where you're lucky or maybe you're not, right? So So Plum Island used to not have water and sewer. And when the Title V regulations changed in the late 90s, banks threatened to stop loaning mortgages or refinancing on Plum Island because you could not come into compliance with the new Title V regulations that required 100 feet of separation, both vertical and horizontal. And it was mostly because the water lens was too shallow and the lots were too small to be able to provide that separation. And so in order for the city of Newburyport and the town of Newbury not to lose, their residents' homes, or B, a valuable portion of the tax base, the town of Newbury and the city of Newburyport entered into discussions with the state on how to exempt or fix the Title V problem on Plum Island. And the only way to do that was to take water and sewer out there. And the only community that had that ability was the city of Newburyport. However, it was expensive for everybody, right? They were going to have to issue betterments to all of those homeowners. And they were also going to have to borrow the money in order to start the project to begin with. Governor King in the 80s had issued an executive order that said the state would not authorize the granting of any funds or special interest loans to any barrier beach that would promote development. All right. So that was a problem because the city and town were looking for low interest loans as well as grants in order to bring the cost of the project down. So DEP said, okay, after many negotiations between the city of Newport, DEP, and the town of Newbury, how do we do this? How do we prevent, quote, development so that you can qualify for these low interest loans and grants? And the way to do that, we all worked out, was that because you were already allowed to do Title V, right? If you could comply with Title V, you could build a house or expand your house. The idea was that if we were to take water and sewer out to Plum Island, you couldn't do anything more to your building, your house, your residence, or whatever, than you could do under the Title V regs, even if you had water and sewer available to you. Hence our limitations in the zoning to not allowing more than 3 bedrooms in any home and not allowing more than single family homes unless they were grandfathered. And so if you have a 1-bedroom home, you're allowed to go to a 2-bedroom. If you have a 2-bedroom, you're allowed to go a 3-bedroom, but you may not go above a 3-bedroom unless it already existed. That also, that's also where the FAR limitations came into effect. And so after many years of negotiating with DEP, which included the agreement that both the city of Newburyport and the town of Newbury would adopt almost similar zoning ordinance and a zoning bylaw, and very similar Conservation Commission bylaw in both communities and ordinance in Newburyport, that they would approve the administrative consent order and authorize the city and the town to apply for low interest loans from the state revolving loan fund. And so that's why the limitations on becoming more generous in your regulations, which I don't think is your question, on Plum Island would be permitted. You'll note that the city of Newburyport has become more conservative in their application of their regulations to Plum Island. They tried to change the ordinance last year. That was shot down. I think they'll probably try it again. But in both communities, you could become more restrictive, but you could not become more generous. That is a thumbnail sketch of the history of water and sewer at Plum Island.
That was an excellent thumbnail sketch. It was very thorough and sensible, and I understood every word you said. Thank you.
Okay, so yes, you could change the regulations on Plum Island. I think they would need to become more conservative, and we would just want to make sure that they were in compliance. There are other political issues you have with that, which is the buzzsaw that the city of Newburyport ran into last year. But from a legal perspective, both communities could become more conservative. So then you asked me kind of from a legal view, kind of the failings. And this is a big question I'm not going to be able to answer. The failings of either the WPA or the bylaw and how you can address those failings from our bylaw. So that is a really big question. And without specifics, we all could have this huge conversation over and over. But I'm gonna refer to the proposed changes in your bylaw. And let me just say a couple of things. The cases say that if you are going to have your own local bylaw, that you have to show that you have something special to protect that's more important from a resource area, environmental area, that the wetlands protection bylaw doesn't protect. You have to go an extra step, right? So otherwise, all you can do is apply the wetlands protection bylaw and regulations. Now, many communities do that. You just have to be careful how you draft it, but that's the big picture, right? If you were going to draft things that are more restrictive than the Wetlands Protection Act and its regulations, you have to state why it's important that you do that. Why is Newbury unique? And it requires to have I'm going to just say out hypothetical things because I can't tell you what it is off the top. So, but if the state says you have a 25-foot no disturb, right? If the state said you had a 25-foot no disturb, and you said that you have a 10-foot no disturb, you have to explain why that's important for Newbury, why there's a unique environmental concern in Newburyport, in Newbury, that extra 15 feet is going to protect, okay? If you're going to protect non-certified vernal pools as opposed to certified vernal pools, you need to state why that is unique to the town of Newbury, or what special thing that you're trying to protect that you think that the state bylaw doesn't go far enough. Now, all of those things are possible because they're done every day across the state. And you can do it too. You just have to make it clear in your purpose section of each one of those sections or your performance standards when you adopt them, okay? So that's kind of the high level. How do local bylaws get thrown out in court? They get thrown out because they're doing the exact same thing that the State Wetlands Protection Act is doing. You're just trying to enforce it differently, right? So you have to, if you draft something more restrictive, you have to say why it's important here that you're drafting it more restrictive. That's the first big thing. The second big thing is you need to set standards. Courts hate it. Courts hate it when they say it's left up to our good discretion, right? It's up to our discretion because we get to decide. Applicants need to have notice. What standards do I need to meet? What is the standard? And then the determination should be the commission will apply those standards in your own opinion. It's still your discretion, but it's your standard, right? You'll apply those standards to determine whether or not a permit should be issued. Okay, so let me give you an example. I get concerned when I see things like you have in 95-2.1, you have two provisions that make me nervous. Any activity deemed by the commission as likely to have a significant or cumulative adverse effect upon a resource area as defined herein. Okay, any activity deemed by the commission based upon what? Right, I just need a little bit more, just a little bit more.
Yeah, Lisa, so, and I think that maybe my thoughts about this were going to be that the way we opted to do this based on looking at other towns' bylaws was to talk here about where we were going to have jurisdiction. And I think this isn't anything we crafted. This is probably something we borrowed from another town.
Yep.
And the specific regulations or to use your word, the performance standard attached to that statement would be developed through regulation after the bylaw was adopted. Now, if you think that we should change this language before
Yes,
then, that's worthwhile. I just think that our intent was that the specifics around all this was going to be done through regulation.
So you can do that, and it should say, any activity deemed by the commission pursuant to the regulations adopted hereunder, right? That you just need to say that that's what it's going to be, right? So that then you can set forth those standards in your regulations. The next section does the same thing, right? When you talk about any activity, including but not limited to any and all of the following activities, when undertaken to upon land within 300 feet of a buffer affecting resource areas or their wetland values as determined by the commission, right? It should say, you need to actually say the words in accordance with the regulations, right? So that somebody knows where they're going to go. Like, what are you going to determine it on? And it can be values, right? It can be your wetland standards that you get to determine, right? Is it protected enough? Is there going to be too much whatever? Are you not going to be able to, to replant that, whatever it is, is there going to be impact to the ecosystem or to the natural habitat of, wildlife? But you need to say that. That's all I'm saying, is that you need to complete that thought and don't assume that. Because if I'm looking at this, right, think about this. If I'm an applicant and I'm looking at this, I want to know what do I have to do? Right? What is my standard? You can't make me guess. You got
No,
to.
I think that's clear and very, totally clear. And thank you. That's great advice.
So I think those, in 95-3, all the way at the end, section 9, when you talk about vernal pool habitat, you say isolated wetland may be presumed to include vernal pool habitat unless otherwise demonstrated by the applicant. Is that may or shall?
From a legal perspective, what's the difference between may and shall?
Well, it depends on your standard. If you're saying that an isolated wetland is going to be presumed to include a vernal habitat unless it's demonstrated by the applicant, then you're going to presume that all vegetated wetlands are vernal pool habitat, and that the applicant has to show that there's no wildlife in there, right? That's a broad.
That's bold.
That's a broad statement. So I point that out because what you might want to fix that a little bit, because what's may, what is may? That's the other thing. So you have the right to make that determination, but again, we're looking for some standards there, right? Because you've decided that it doesn't have to be certified, right? So if it's not certified, then what is the standard?
Exactly.
And you guys, I've talked to you guys about this a little bit before, so I think you just need to look at that a little bit. You don't want to be too big, because think about how big that is, right? That's in Newbury, all isolated wetlands. You don't want to do that, but you do have.
That's a great point. I think that's not an intent. That's just an honest mistake.
Right. But that's why we have these conversations, right? So take a look at that section a little bit and refine it a little bit more. I see what you're trying to do. You just need to be, here, these things are going to be considered this, and it could be, they're going to be considered this if there is any wildlife habitat in there, right? If you can show me that for X number of seasons, there's wildlife habitat in there. It's kind of like a perennial stream versus an intermittent stream, right? There's a standard for that. We know, right? There's a couple of ways we can determine whether a stream is intermittent or perennial, right? You can take the floodplain calculations and all of that, or you can watch it and observe it. And does it stop any more than X number of days when there's not a drought? Those are the standards. We know what they are. I know I can go out and measure it. Is this a vernal pool? I mean, a intermittent stream or a perennial stream? Well, same thing. If that's what if you're going to say that this is important for these reasons, how are we going to determine that? Because you certainly don't want to encompass the whole thing.
This is Frank. I have another point on that. It says in 95.3, what you just pointed out, but then if you go back to 95.2, it says vernal pool, a 100-foot buffer zone there too, vernal pool habitat regardless of size, location, or certification status. So basically, in the way I'm reading that is whether the vernal pool is certified as one or not, they're required to have a 100-foot buffer zone.
Yeah, Frank, that was purposeful. And we, that was a lot of deliberation that went into that. And the commission at the time felt that if all evidence on the ground was that it provided the functions of a wetland, provided the functions of a vernal pool, that we were not necessarily going to be bound by the timelines or the whims of natural heritage in certifying that vernal pool. And I think that there's ups and downs of that. It's certainly a case where we're probably being more, you can either say conservative for the resource or restrictive to development, either way you want to put that. But it also provides a great deal of clarity when you sit on the, you avoid situations like some we've had where everybody sits there and says, this really looks like a vernal pool, but it's not on the vernal pool registry yet. And they haven't done any of the work to see if it is a vernal pool or get it certified by natural heritage, which if we really want to put our feet down could be like, you want to wait 6 months, 9 months to see what comes up in the spring and what's going to happen with it? Or do you just want certainty when you go to plan out your project and know that's a vernal pool? Let's just treat it that way. And then you can have your project and move forward with the logistics, the planning, construction, and everything else. So there's ups and downs to it, but that was one of the things we deliberated on and felt fairly, but it was one of the things we wanted to accomplish with the bylaw amendment.
But
Yeah,
it
so I
seems to
think-
be in contradiction with 95.3, number 9, where it says, provided it otherwise meets the certification criteria of the Massachusetts Natural Heritage and Endangered Species Program. So it just, those two things seem to be contradictory.
No, those actually,
Oh.
to Ben's point, they line up, I think, pretty well.
Yeah, so nine is defining an IVW, an isolated vegetated wetland. It's not defining a vernal pool.
Okay.
So there's what the 9 is saying is that an isolated vegetated wetland is any of these things, unless the wetland is or can be certified as a vernal pool.
No, I'm
and
talking about the paragraph above that.
oh, I thought you said
Vernal pool
9.
habitat, I mean, any vernal habitat, a vernal pool habitat,
Oh, yeah.
I mean, any vernal pool, whether or not. So that seems to be in contradiction. That's what I'm pointing out. I just think those two things are in contradiction.
Yeah, I think that, I think I get your intent. I think you just need to spend a little bit more time on it to understand what the implication of it is and how it's applied, right? So just go back and take a look at that again, I think.
Yeah, and Frank, you may be finding something that I know we talked about that and intended to make those definitions lined up. So maybe this draft or should never happen. Thank you, Frank.
Yeah, and Frank, to your point, we were just trying to make sure that, to what Ben said, there is a clear standard. And so instead of waiting for something to be certified, we could, take the paperwork, that says this is what the standards are for certification. And we could look at it and say, yeah, this looks like it'll certify. So therefore we can just treat it as such. To my memory, is what we were trying to do there.
Yeah.
Can I ask kind of a clarifying question that, depending on the answer, might be something that we're going to want to bring up during a public workshop session? So in the event that, say, the commission determines that, okay, we have an IVW that we are going to consider a vernal pool, now we have a 100-foot buffer zone around it, that any regulations that we put out in this bylaw are going to have the same as the Plum Island ones do, are going to have a variance option, and the variance option requires that there have to be, alternative analysis that they have to prove to the commission based off of all of their evidence that this is the only option they have is to get within 100 feet of that vernal pool that we've determined, to break that 100-foot buffer zone. It's not going to be like, regardless of what anybody says, whether you like it or not, you only have you have to, maintain that 100 feet. There is going to be like the variance option. So the regulations don't always.
So Sam, I think you might be jumping the gun a little bit there, right? Because 100-foot buffer isn't 100-foot no bill.
Right. But
Right, and
the,
so,
I think Sam's point was that for any of these regulations, regardless, you have a relief valve, right?
right.
And the relief valve is the variance, but the variance really should be used sparingly, right? I mean,
Right.
and that's why the standards are important. And maybe the regulations in your performance standards say, if the habitat and the pool is mostly located at X, and I think you can just get some performance standards that allow you to do things that you want to do without having to slide into the variance. And of course, at the very end, you have to slide into the variance if you have to, but the variance should be used sparingly, because otherwise what use is the bylaw?
My concern with this is that we may be inconsistent in the way we apply the regulations. And what I mean by that is we have a project, maybe we have a project that is very unpopular with the abutters. And so we apply very strict standards to that project. And then we have another one that is a more friendly project, meaning it's not opposed by abutters, but it still involves a very similar crossing into a resource area. And are we then setting ourselves up for a claim of being inconsistent or partial to certain people or organizations? That's my concern.
So let me, and Peter might want to pop in this because he gets it on the other end of the planning board. So let me just say, first and foremost, that every one of your decisions is a separate decision and doesn't set precedent. So that's the big picture. But to your point, Frank, in order for you to have validity and consistency, and to have the public have confidence in you, you should apply your bylaws evenly to the situations which are identical, essentially, not identical, but close, right? So you're right. And your job is a really hard job. Any land use board has probably one of the most difficult jobs in any city or town of any other board, because people come in and they want to do stuff with their property, and either the neighbors are really happy or the neighbors are not. And I think your job is as difficult as it is to try to stay as true as you can be to your purpose of your regulations and the state statute and the overriding principles behind them. And there's a lot of flexibility in that, right? I mean, general health and welfare, how are things protected? How aren't they protected? You look at your purposes section: protection of groundwater, protection of public and private property, flood control, storm damage rate. Those are big purposes. So I think that it's a difficult job, but the way you can be and keep your integrity is to try to apply that as fairly to each different situation that arises. And quite frankly, try to mute the interference as much as possible, but understanding that sometimes it does have an impact, but it's hard. I mean, geez, Pete probably hears more of that than on the planning board side than, you do as a conservation commission, I think probably, but it's not easy. And so you can get up every day, you know, trying to do that as fairly as possible and as true as possible to those general purposes is the way you're going to be able to come to every meeting.
Right.
Frank, I'm a
That's,
little,
I think, and that's why I think having defined standards, for example, prevent storm damage. How? How do we prevent pollution? What are the requirements for someone wanting to do work, and what are they required to do to prevent pollution? What are they required to do to prevent loss of beneficial, you know,
Right.
it's too loosely worded for me. It just doesn't give enough definition for
Well,
me to feel comfortable, you know, applying them.
Well, I think if you look at bylaws, so here's how I kind of explain this stuff. So if you think about it, the Constitution is chapter 131, right? That's the Constitution. It's big picture, right? Big picture. And then it gets to be a little more refined when we adopt a local bylaw, right? It's a little more refined. We still have general big purposes because that's what we're required to have, right? Why are we able to do this? Because it's our job as the Conservation Commission to protect those big interests, right? Okay, well, how, to your point, how are we going to protect those big interests? Well, I'm going to tell you specifically how we're going to test in the bylaw. Here's what we expect of you generally in the bylaw. Here's what we expect. And oh, by the way, to be really clear, I'm going to tell you specifically how to do it in my regulations, right? So I'm going to go from the big picture of the Constitution, chapter 131. I'm going to adopt a bylaw that is a little more specific because it applies to Newbury and not to, you know, to Sudbury, right? It applies to Newbury. And oh, by the way, once I tell you that, why it's important for Newbury and these issues here and our requirements, I'm going to tell you specifically what the performance standards are going to be for you to come in and get your permit from us. And here's what they are.
Right.
yeah. And Frank, that's a decision tree we made. And I understand your concern. That was kind of like the tree we faced early in this process, and we chose to take the approach of doing the bylaw amendment, passing that at town meeting, and then crafting regulations at meetings of the commission, which we would be able to do because we felt like that was we want to provide those details. We're not going to do any enforcement of anything we're talking about in the bylaw until we have specific regulations. We're not just going to lean on the bylaw. We're going to create regulations to address those things that we've added in. And we want to have that clarity, as we've talked about a lot, but we had chose to do that in that manner where we're going to say, all right, this is the big picture stuff. Do people agree to it? Does this pass at a town meeting? And then we'll create regulations as a commission afterwards, rather than create these really specific regulations and have this big dense document that people had to go through. And then maybe there's general support for, you know, increasing buffer zone protections as an example, but like people will be like, well, I'm not going to vote for it because I want 50 feet versus 25 feet, where we can have a discussion and incorporate public opinion afterward and not have to worry about it's big people getting upset about tiny little things and little details that you could compromise over and come to a consensus on. But, you know, town meeting's not the place to do that. Does that make sense?
Yes,
Does it address some of your concerns?
it does. Yeah, because I wasn't aware that was the plan. I'm sorry. I kind of came into this late, so.
Yeah, and it just means that Brian and myself and Mary didn't do a good job of briefing you either. So don't say sorry.
Yeah, and Frank, just to follow up on Ben's point, you know, the root cause of what we're doing is exactly the concern you're raising. You know, in a manner of speaking, the WPA is perfectly clear on easy land to develop. And in the last couple of years, you know, people have started bringing up oddball situations and oddball questions that we don't have clarity on. And, you know, just as you were saying, you know, this feels too broad and, you know, it's too unclear what we would be doing here. You know, we've had circular conversations about clarity and what we should, could, would, you know, all your adverbs there. So, the more specificity you want to see or have ideas on, or, you're talking to the right crowd, because we would like that. That really is the root of why we're trying to do this.
Okay,
I
good.
think Peter had something to say.
Yeah, I was just going to comment. When it does come to proposing this, the commission has to really do their homework and allowing people to understand that the regulations that will follow will be then, the decision process will be made within the commission. Because I think it gets a little bit too confusing when too many things are brought before the body and there isn't enough preparatory work to explain the intention and where you want to go with it. And so that's, I think, the work that's going to be necessary to be done prior to this, getting to that point.
Well, Peter, that's a good point, because I recall at the last town meeting when this was brought up, there were people claiming that it was going to preclude them from being able to replace the deck on their house, or it was going to preclude them from being able to replace a shed that was currently there if it needed to be replaced, So I think there's a lot of angst in the community based on feedback I've gotten, that this bylaw is going to really restrict property owner rights. And I think we need to address that.
I would make a couple of suggestions. First, I want to add my last comment on the bylaw in 95-4.1. You should just add at the end of that sentence, consistent with this bylaw. So this is, to your point, Frank, specific performance standards for work or activities within the wetland resource areas described above may be provided in regulations adopted by the Newbury Conservation Commission consistent with this bylaw. I would add consistent with this bylaw at the end, first of all. Secondly, you may want to consider, and it's a lot of work, so I don't know that you want to consider it right now, but I have another community right now that is adopting an outdoor seating zoning bylaw. And it actually takes away some of the power of the planning board, and the planning board's an elected planning board and they're all up in arms about it, right? So in order to help kind of calm them down a little bit, the committee drafted the regulations in draft form, right? So that the planning board, who is actually against this amendment, can see that that the building inspector can only issue these permits under very limited conditions, right? They could actually see what the requirements are now, even though the bylaw is not yet adopted, right? So that was easier. It's a smaller kind of thing, but I believe they're getting the buy-in of the planning board in that instance, which has to give a recommendation to this town meeting, right? So I tell you that because it may be worthwhile going through the exercise of actually getting draft regulations ready, because then if I'm a concerned citizen, to Frank's point, and I'm worried that I can't put my shed in my backyard because my neighbor has a pond, right? Then I'm going to find out that, well, maybe I can put my shed in the backyard because here's the performance standards, right? I don't, maybe I can't dig a foundation, but maybe I can put it on piles, right? Or whatever it is. I don't know. So you should think about that, right? Or maybe even not the whole set of regulations, but regulations as to the specific performance standards for those things that may be more touchy, if you will.
Yeah.
I like to throw something out there just in case anybody is hearing discussion about, drafting regulations and stuff. We are not going to have this ready in time to get on the spring warrant. The requests to get on the spring warrant are due February 7th. We are not going to have this done. So we have time. We have time to start really thinking about this.
Yeah. So then I would take the time to do it. So you put a whole package together, right?
Yeah.
You may even want to consider examples, right? You may even, as part of your presentation next year, even consider examples, like that, you could do this. If you're here and this is this, then you could do this if you follow these performance standards. I don't know. But, there's nothing in the bylaw, in my mind, that is off the charts, right? So it's all in the performance standards, right? It's all in the performance standards. So those are my overview comments, and obviously I'm happy to continue to review this in more detail as you move forward.
Frank, is there anything else that, I mean, these are all good questions, and I'm just wondering if the well is dry or if you've got a few more, because they are helpful.
No, honestly, those were my concerns. You know, I made a list, and I think they've all been pretty much addressed. So, but thanks for asking.
All right. I mean, you know, like Ben was implying, you know, we've gone around this before, and so, you know, our eyes aren't fresh, and so a pair of fresh eyes, you know, does help.
Thank you.
Yeah, I want to say thank you, Lisa, for those notes, and Frank, for your points. Those were great. And Brad, I did see you nodding when Lisa brought up the example of, or the idea of having example regulations or draft regulations. Do Frank and Brad, you both seem to think that would be a good idea. And you're muted.
Absolutely. I think that's a great idea. I think it'll alleviate some of the, you know, unfounded fears that may be out there, you know.
Yeah, I agree. I don't think we should be proposing a bylaw change without showing the cause and effects of all of this, including the regulations.
Okay. Well, more to do.
All right.
All right. Happy New Year, everybody.
Happy New
Thank
Year,
you.
Lisa.
All right.
Thanks, Lisa.
Take it easy. See you guys around.
Thank
Well,
you.
great.
Bye-bye.